Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West, transmitting across the internet. This one is actually 306. I said 306 last time, so this one is actually the 306. How are you this evening, Larry? Anything exciting? Oh, it's probably hot as hell over there, isn't it?
It is indeed, and I just hit the start button after you started speaking, so I hope you didn't miss any important stuff.
I think it'll be fine. I'm not making the backup to the backup to the backup, so hopefully everything works out. If not, well, we'll figure it out. And Chance, West Coast, how's it going?
Cool as can be. Cool as can be.
Cool. And just a nice, comfy 75 degrees as always?
Maybe even not even 75, maybe just 70.
Larry, is it 70 there?
99 last time I checked.
Ooh.
All right, well, make sure that you press like, subscribe, and all that stuff so that Larry can have an air conditioner. You don't have an air conditioner in there?
Oh, we do. It's working this year. Remember, they replaced it last summer.
Oh, then why are you complaining about doing the podcast in the summertime if you have AC this time?
Because I have to get to the office, and it's 105 to get here.
Is it 105 in your car with air conditioning?
For part of the way, I park out in the driveway, and the car is blazing hot.
Wow.
You don't have a remote starter to fire the thing up and turn on the AC?
You know, I can't afford such luxuries as that on the salary I get paid.
I see. All right. Well, okay. Anyway, so press like, subscribe, and thumbs up, and all that good stuff. And then what else? Make sure that you go over to Patreon and support us for as little as $1 a month. That would be fantastic. We even got a new patron tonight. We got one during the week, and I'll announce this all at the end of the show. And then you can get on Patreon and listen to us record live and whatnot. So, Larry, if you'd be so kind, what are we doing this evening?
Well, we don't have any cases to talk about. But we do have some good content. I was going to talk about a complaint filed by the ACLU, I think in New York, regarding proximity restrictions, but I just didn't have the energy. But tonight we have some listener questions to go over. One of them is from an attorney who's married to a PFR. Another is about getting off the registry in Kansas, and this is from a person who was convicted in Missouri. And we have some articles about the power of false accusations. And we have the California corner with Chance Oberstien.
It almost sounds like we need to have a ding, 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 California corner over in this side of the ring, because he's going to go duke it out and fight it out. That's what it sounds like to me.
I think we need to have some kind of themed music for the California corner, something that sounds all spooky.
Yeah, that would be great. Perfect.
Well then, shall we start with the federal supervised release?
Let's do it.
All right. Well, this, let's see here. So good evening, Andy and Larry. Would you set this up real quick before I do this? Or is it set up here in the script?
It's set up. You had submitted it
Okay.
to me from the person, and I contacted the person, yes.
Gotcha. Okay. So good evening, Andy and Larry. I know I was speaking to the person. I just wasn't sure if it was all the way set up. I spoke with Andy on Narsal Connections. Side note, make sure you go over to Narsal and go find Narsal Connections. It's a social media platform very friendly to PFRs over on the Narsal Connections group. And he suggested that I speak to Larry. I am a criminal defense attorney. My husband is a PFR on federal lifetime supervision. He is currently residing at the Federal Halfway House here in Vegas, pending his revocation hearing. His PO is alleging 7 violations. And his revocation hearing is Tuesday, and this is Tuesday a couple days ago, June 4th. Andy suggested that Larry may be able to assist with legal arguments, etc. Now, not acting as an attorney, but acting as a strategy partner, right?
Right.
And so I understand that you did contact her, and you had a brief conversation, correct?
2 hours.
That's brief for you.
Indeed.
What happened when you talked to her?
Well, I did indeed contact her, and she is amazing, for sure. She's worked tirelessly on this case, and I'm disappointed that we weren't able to do more for the situation.
Did she say 7 violations?
Yes, she did. And I do not recall all 7, but most of them seemed rather weak. The strongest of the alleged violations is that he had accessed some naughty adult pictures on Instagram, and they offered for him to admit all 7 violations and argue for credit time served already in the halfway house pending the resolution at the PV hearing. So as a condition for his release on the PV, he was placed in a halfway house and was no longer allowed to live with her. And in my opinion, she properly advised her husband to reject that offer. There was no reason to admit to all 7 violations. One of the alleged violations was that he was living at an address that was too close to a park. And the problem is that address had been approved by the previous probation officer.
And let me ask you, though, about something like that. If do you get grandfathered because the previous one said okay and now this one says no? Do you have any grounds to stand on with something like that?
In my opinion, he probably would have, but the probation service notoriously changes the story, and their story was that he was given conditional permission provided that he didn't violate a single condition of probation, of supervised release, you should say. And they're saying that therefore that conditional permission was being withdrawn.
And you mentioned Instagram pictures. Now, I'm not really like a social media person, but it's really hard, at least my understanding from everything that I've listened to, tech podcasts all over the place. Like, you can't find nudity these places. So how did they catch him for having nudity on Instagram?
Well, I thought the same thing because I've been on Instagram, but unfortunately, they stretched the definition a bit. They claimed that on Instagram, the pictures of contained certain body parts that were blurred, but you could still make out it was the whatever and the whatever because it wasn't completely blurred, and therefore it meets the definition of pornography because the statute, 18 United States Code 2256 subsection 2, states that he specifically cannot view or possess images of, and then there's the list of everything in that statute, 18 USC 2256. Chance, do you want to give those things that you cannot?
Are you embarrassed, Larry? Okay, I'll do it.
I just saw a bus coming, and he just decided to kick you into the street.
I have no problem. I will say this, okay? Okay. In sub A, except as provided in subparagraph B, sexually explicit conduct means actual or simulated sexual intercourse, including genital to genital, oral to genital, anal to genital, oral to anal, whether between persons of the same or opposite sex, bestiality, masturbation, sadistic or masochistic abuse, or lascivious exhibition of the anus, genitals, or public area of any person. How's that?
Well,
what is a public area of a person? Is this like you can go to Walmart and find the public area of a person?
Nah.
Never mind. Sorry. There's no L in there. Never mind. Sorry. That's totally my bad.
Well,
did I pass the audition?
You did very well.
Okay.
What confuses me about this statute, this 18 USC 2256, is this appears to be what's intended to prevent the production of child pornography. And I don't know how this becomes a condition of your supervision. Perhaps it's in the behavioral contract, which we're going to get to a little bit later. But this seems to be quite a stretch if you're saying that there was blurred out images where you could have, if you studied it strongly enough, you could imagine what was underneath the blurry part because it wasn't completely blurred out. But yet it was an adult. And this statute is designed to protect children and minors. I don't understand how this was allowed to stand. But we're going to have her on it at some point, and we'll hopefully get more into this.
That seems super weird. Yeah. So, do you think it'll be next week, or because otherwise it'll be like after the conference, and then who knows what's happening after that?
I don't know if she was having to decompress after the 3-day hearing. And I told her in my 22 years of unauthorized practice of law, we've never been allowed 3 days on a probation violation to put forth an evidentiary hearing, to put on an evidentiary hearing. And I talked to Chance, and he said, nope, happens all the time. But I've never been in one where it went on for 3 days. But he was sentenced to 3 months in jail, followed by 3 more months in the halfway house. In addition, he's no longer permitted in the house that they jointly own.
This is really bothersome. Like, seriously, because I'm just going to make the assertion that YouTube has a similar content policy to Facebook and Instagram, and I could have that completely wrong. But you can search hard on YouTube to find anything that has any naughty stuff, and you can't find anything naughty. You can find incredibly close to, but not to my knowledge can you find anything where anything is shown.
Well, that was my thing, and I don't think that it's fair. Not only is it not fair, it's not constitutional, in my view, to tell a human being that you cannot have sexual urges. And for them to say that he cannot look at attractive women or guys or whatever he's looking at on Instagram and use those photos as a stimulation as a part of their behavioral contract, I think that's gone too far. I thought we had talked about this on an episode where there was a case decided that addressed that particular point, that you cannot tell a person not to have any sexual urges and not to look at anything stimulating. Neither of us were able to find it in our vast trove of archives, but I could have sworn we've talked. Do you remember a case where we might have talked about, because I thought we had talked about such a case.
I don't recall offhand. I do have a question for either of you two. Someone in chat said, does that mean just seeing a shirtless man playing basketball meets the definition? If that would be the thing that would be, so inclined for you?
Not in my opinion. Question.
Not in my opinion. No.
Interesting question, though. If a shirtless man, I mean, there are nipples on males as far as I know, right?
I've heard so.
They may not produce the same outcome, but they're there. So what if the probation service takes the position that that is nudity or provocative?
Right.
Yep. I mean, this is a slippery slope that has no end to it. And to think a federal judge spent the better part of 3 days, was not the complete 3 days, but they were in hearing for 3 days, dealing with Instagram pictures, with all the so-called bad crimes that are going on out there, for a person who's happily married and hopefully being a productive citizen, that now we're throwing him back in the clink to spend money on him, is just mind-boggling.
That is mind-boggling. If you're going to invite Anya on, I have a parallel case I've just handled in federal court. Very similar. I don't really know the facts of this, but it's very similar. I'd like to be able to do some cross comparisons when she does come on.
Well, if we can't get her this coming week, we will get her. But she said that she was somewhat devastated by the outcome, and I can understand that, because you work so hard to try to reintegrate, and all of a sudden this stuff comes along and it's all taken away, and you got a 6-month setback, plus you got to sell the house. And it's a good time to sell, but it's not such a good time to buy.
One other point that just got brought up is, and sentencing him to banishment from his home with his wife. WTF is that? And I mean, I had something in my head I wanted to bring up after that, but isn't that pretty harsh just for like a PV violation?
Well, I don't think it's all that harsh per se for a probation violation, but you look at the totality of this circumstance. The guy's masturbating to scantily clad women. That's a healthy thing to do.
You would think if he's releasing the demons then he would not be out preying on whatever they're afraid of him preying upon.
You would think so, but it's an example of our over-resourced law enforcement apparatus. If they didn't,
there you go again, defunding the police.
If the probation service didn't have the ability to bring such cases because they had heavier case loads that they had to monitor, we wouldn't be facing this. But anytime you start talking about trying to reduce the amount of resources that the law enforcement regime has, the conservatives go ballistic. Now, I'm hoping that this thing with Trump, if they're intellectually honest, they will start to say, well, maybe those pointy heads have a point, because all the effort's been put into convicting him is only because they have the resources to do it. Not only because, but partly because of that. I mean, they've got cases going from coast to coast. And if you don't give them the resources, they'll have to make difficult choices. And this is just nonsensical in my view, that we're spending this kind of money on Instagram pictures. Really?
Yeah, I don't get it really at all. All right, moving along then.
Yes, well, amazingly, there won't be anybody on the conservative side of the aisle that will criticize this type of waste of resources. You won't hear anything about that, and that's the sad thing about it, because we need to be dealing with the systemic problem that needs to be fixed rather than making it a personal thing about one individual. The system is overkill across the board.
Yeah,
very well. Moving along.
I would say splitting
go ahead,
hairs.
Chance, I'm sorry.
I'd say splitting hairs in this case, but I neglect to use that analogy. Really. Let's move on.
All right. Well, this is a question from Matthew. Here's my situation. I was charged with sexual abuse, a Class C felony in Missouri, and I received a 3-year sentence. I served all 3 years from 2003 to 2006. At the time, I was 23 years old in 2001, and the victim was 24 years old. The reason I am reaching out is that due to a disagreement with my therapist, I was kicked out of the program about 6 months before my scheduled release date. Now, approaching 50 with no other felonies, I even moved from that area to another state. However, I'm required to go back for court proceedings. What are my chances of being removed from the registry? Also, do you know any good lawyers who could assist me? Lastly, what is your best advice to improve my chances of being removed from the registry? Thank you for your time and support. FYP. Thank you for putting the FYP on there.
So I've actually communicated with this person on several email exchanges, and so I'm going to read some of the stuff I have written to him. I said, I'm having difficulty connecting the dots. You do not have to go back to Missouri to get off another state's registry. In fact, Missouri cannot remove you from another state's registry. Where are you currently located? That's the state that can remove you. Missouri cannot. And then Matthew wrote back. He said, okay, I get what you're saying. I am in Kansas now, but I got my case in Missouri, and I know I have to go back even though I hate every part of Missouri. My question was did Kansas fix the way to get off the registry? And seeing if I didn't finish the program, should I even try? So he's saying that despite what you told me, I have to go back to Kansas to get off the registry. And should I even try? And I responded, in my opinion, you should not try to get off the Missouri registry unless you live there. Kansas is not bound by anything that is done in Missouri in terms of registry removal. Assuming Missouri does grant your termination, that is not binding on Kansas. Kansas will have to grant you termination from their registration obligations. Does that make sense? Have you contacted an attorney in Kansas? So, and then he responded again. You want to read that? I'm exhausted, Andy.
I'll read it. Yeah, you read 3 sentences and you're exhausted. All right, I'll read it. I apologize for not addressing your previous question. There wasn't one to begin with. I've consistently adhered to the rules. After my 3-year stint at MODOC in Missouri, I relocated to Kansas. It's crucial to highlight that nearly 20 years as I have passed, it's crucial to highlight that nearly 20 years have passed without any charges or incidents. Additionally, now at 46 years old, I simply want this turmoil to cease. I'm weary of incessantly fretting over trivial matters such as whether I have to pay the $20 to register or if there is a new investigation looming over me. I feel I'm beyond this. I mean, shoot, it's been 20-something years for him. The only crime I've ever been involved with dates back to the charge I received in 2003. I would tell you, Larry, I get his point. Can he file his removal petition in Missouri to get off the registry? And why? Why? As always, Larry, are you Mr. Doom and Gloom, and why do you have to make this so complicated?
Well, the courts are open and they will generally accept filings, so he can certainly probably file in Missouri if that's his wish. But I do not understand how Missouri can remove him from another state's registry.
Are you saying that there are no circumstances where the state of conviction cannot impact the removal from registration?
No, I'm not saying that. There could be some circumstances where that could occur. For example, if a person's conviction was overturned, that would likely be sufficient to end registration, the registration obligation in another state. Another situation might be if a person's conviction was not covered by the other state except for a catch-all provision that requires registration simply because you're required to register in a state of conviction. Hypothetically, a person that was under that catch-all provision might be able to have their registration terminated if the state of conviction ended the person's obligation to register. But those are nuances. But generally speaking, a state can't remove you from another state's registration.
And what about Matthew filing for removal in Kansas? Would that be an option for him?
No. It appears that Kansas does not offer a pathway off the registry. According to the ACLU of Kansas, for several years, Kansas lawmakers have pondered changes to make the state's offender registry less restrictive. During the 20 and 21 legislative sessions, lawmakers proposed reducing penalties for failing to register and changing some of the violent and drug offense registration requirements. They also considered adding an avenue for registrants to petition for removal through an application process. The 2021 bill had bipartisan support, including from law enforcement, but it died in committee. And most recently, in the fall of 2021, the Kansas Criminal Justice Reform Commission subcommittee on proportionality of sentencing considered whether drug offenders' information on the same public registry as PFRs should be made only available to law enforcement. The subcommittee also considered potential changes to reduce the penalty for failing to register. Nothing has passed so far as best I can tell from my limited research.
All right, and I see that they also then stated some legislators have wondered openly if the CORA goes too far. It does. However, they have failed to act on their concerns. Meanwhile, the number of Kansans included in the registry has ballooned to nearly 1% of the state's total population. What do you think it will take to change?
Well, it would take electing different people to the Kansas General Assembly and possibly to the governor's office, because if you get past the General Assembly, you got to get past the governor.
Now, do any of you care, and anybody in the audience, does anybody care what the ACLU has recommended for their changes?
Of course they do.
All right, so here's what they recommend. Strictly limiting the types of offenses for which registration is required under the Act, reducing the length of time that people must register, providing a way for all affected individuals to petition for early removal from the registry, drastically reducing the consequences for violations of the Act, allowing for remote registration options and other mechanisms that will reduce the impact on registration on individuals' daily lives. To me, these don't sound unreasonable, but do you think they will pass?
Don't know, but looking at the makeup of the Kansas Assembly, it does not look promising.
I'm assuming they're not very pro-criminal justice reform there?
Well, it's funny because they could be. You know, they're under conservative domination, and the conservatives don't get vilified for being soft on crime. They don't generally vilify themselves, and very few liberals vilify conservatives for being soft on crime. So they have the latitude to do it. They just don't have the will because they're not hearing from the people of Kansas that they want these changes, apparently. And folks, if you're going to vote for these people, you've got to communicate to them what you want them to do. And they have to hear a groundswell of public support. Otherwise, they're not going to do anything.
Larry, I think the person that wrote this letter is in chat. Oh, hey, this is him. I had no idea. I don't know who anybody is in chat. Everyone uses some pseudonym. But the person we are speaking about is in chat. And he says, so pretty much I have to move back to Missouri to get off the list. But you could still wouldn't you end up in the same situation then of still being on the registry in Kansas, potentially?
Well, I don't know if they keep people on after they leave, but he wouldn't have any forward obligations. We had that debate about years and years and years about whether being on a website is the same as being required to register. And some people think it's the same thing. I think it is not anything approximating the same thing. So if Kansas is one of those states that keep people on the list, he might find his image on the website, but he wouldn't have any obligations or any consequences in terms of potential punishment for not complying.
And then is Missouri pseudo like Florida and leaves you on their website infinity, or is he still actually on the registry in Missouri?
Well, I don't know the answer to that, but Missouri does have a pathway off, I think, and that's what he's looking at. He wants to file in Missouri, but Missouri can't help him. If I'm the responding party in Missouri, I'm going to say he's not registering because of us. He's registering because of Kansas, because I don't want to do any work, and neither does anybody else. So they're going to try to extinguish the petition. And he may be able to bypass that and claim that he has a viable need to have a decision from Missouri. Okay, he spends a whole bunch of money and time. He gets a decision in Missouri saying he's no longer required to register. That did do nothing for Kansas. So he's in the same position, only he's broker.
That's I don't comprehend the whole Missouri part of the equation. If he doesn't live there, then why would he have to go back to Missouri to get any relief?
Well, he doesn't have to. He was under the mistaken impression that was the only way off because he doesn't have a way off in Kansas. So in his mind, he wants to go back and file the petition where they have a removal process, and he doesn't connect the dots completely that even if that were to succeed, I would do my best if I were representing Missouri to say, don't bother us with this, it's not our problem. But he believes that if he were to get done and get an order from Missouri, he believes he could go wave that around the country, apparently, and say, I don't have to register anymore, but that's just simply not the case.
Because Georgia would be a place where if you move in and you are registering somewhere else, then you register in Georgia, whether you're on supervision or not. If you are required to register somewhere else, then you register there. It's not worded as if you have a conviction. It's worded if you are registering somewhere else, like Florida.
So, but in some instances, if that's the only reason, like say if you moved to Georgia and they didn't cover your offense but for the catch-all provision, and you were able to overturn that conviction or get that conviction nullified, then Georgia or whatever state might be willing to take you off if you're only registering because of a catch-all provision. But that's not the case. Most sex offenses translate to something because they have loose enough language that says substantially similar elements. Very few states have the language we have that says that it has to be an equivalent. And I tell attorneys that don't seem to understand the difference. Substantially similar is not the same protection as equivalent. If you look at the dictionary definition, equivalent has different requirements than substantially similar. Chance, would you agree or disagree with that?
I'd agree with that. Yeah, there is a distinction.
So if you were trying to make an argument, would you rather be fighting for someone who had the protection we have that it has to be equivalent, or would you rather be fighting where it says if the offense has substantially similar elements? Which battle would you rather be in? I would rather be in the equivalent.
Well, certainly.
Right.
Certainly.
So, but he may end up if he files in Missouri, he may end up getting an order of removal, but that will be of no benefit for him outside of Missouri.
Very well.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
I am going to move over to this. I'm going to play this in the background, Larry. Just the video will be going, but I'm going to follow the script because I didn't have any time to make the clips. So this is a story from ABC Channel 6 in Philadelphia. And, like I said, I plan to play the video, but I'll just read part of the transcript. And it says, "We reported on a month ago, and tonight I spoke with the attorney who represents the man who was accused of attempted rape and kidnapping in this grocery store parking lot. That attorney tells me that the woman's story never added up and that an update in the case is better late than never. 41-year-old Daniel Pearson is home with his family tonight, out of jail after the Bucks County DA says he was wrongly accused of attempted rape and kidnapping. This is the woman who accused him of those crimes, 20-year-old Angela Aramovich. Police in Middletown Township said Aramovich called them on the night of April 16th, claiming a man grabbed her in the parking lot of the Redners off Lincoln Highway and attempted to pull her pants down while he carried her and pulled her back toward his truck. Aramovich said she was able to break free and that he drove away. Police used a license plate reader system that spotted a similar truck nearby. They tracked it to Pearson, and he was held at the Bucks County Correctional Facility on $1 million of bail. This is terrible if he had, I guess it would have been terrible if he'd actually done it, but that's not what happened.
Yes, a new complaint now states that Daniel Pearson was charged with multiple felony offenses and remained incarcerated for a total of 31 days before, how do you pronounce that?
Aramovich.
Aramovich admitted to her lies. The police and DA deserve credit for continuing their investigation. Normally, when they put a person in cuffs, it's so easy just to say, we got it. And, victims of sexual assault, any type of sexual offense, they don't lie. They don't create stories. If they say it, we don't need any further investigation. We don't need, because we're just re-victimizing them, Andy. I don't know why you can't understand that. But anyway, the police in that part of the country and the DA deserve credit for continuing an investigation, because otherwise this man would be still sitting in jail and possibly facing a long term of incarceration.
The complainant states that shortly after his arrest, officials received information from Pearson's family that warranted further investigation, so detectives reviewed surveillance video and found at no point in the video did Pearson's truck travel through any part of the path Aramovich claimed the vehicle took. Aramovich was also called to the DA's office for questioning last Thursday, and because of more inconsistencies in her story, she was called back in on Friday. That's when the complainant states Aramovich admitted that she had lied about the entire incident and that no assault occurred. This is disgusting. Why would a person do such a thing?
I get that question all the time when I'm lobbying. People say, well, Larry, why would people make false accusations? And I said, well, there's a whole litany of reasons. They could do it because they don't like a person. They could do it in custody battles. They want to discredit their spouse for custody reasons. They can just do it for outright meanness. So I don't have any way to explain why this woman, this 20-year-old, did that. But in her own words, she stated that, quote, she had seen Pearson in his truck before in the parking lot of her old job, and he was quite creepy.
Creepy?
Now, yes, creepy. Now, that doesn't seem like enough of a reason to accuse someone falsely. There's never enough reason, but a person looking creepy, if we went around making up criminal accusations on people that look creepy, they would be, that's all we'd be doing. All charges against Pearson have been dropped, and now Aramovich is facing charges herself. She's currently in jail and due back in court sometime later this month. Can you finally admit that this is funny?
No, this is anything but funny. How long did he spend? 31 days in the lockup? That's not funny.
But it's funny that she's in jail now, isn't it?
I guess that would be karma. But anyway, what do you think will likely happen to her?
Yeah. Making false police reports is generally a criminal offense in most states, either felony or misdemeanor. In this case, including Pennsylvania, which under 18 PA Constitutional Statute Section 4906 makes it a misdemeanor to submit a false police report or complaint subject to fines and jail time. How long will she stay? Probably not long. A misdemeanor just, doesn't do it.
Doesn't that even maximum of a year?
Well, misdemeanors are different. Some are up to 6 months, some up to a year. But let's just say that this is 6 months tops, and she gets half time, 3 months.
And then we have moving over to, we have another similar story that comes out of Colorado where a woman made false accusations. She was sentenced to serve 4 years in prison. Now, is that appropriate punishment? Like, in my mind, if you have then falsely accused somebody and they spent 31 days in the lockup and 4 years, I don't know that that's enough time. Come on, man.
Well, it's hard for me to say, but let me tell a little bit about this. We are not going to spend a lot of time on it, but what happened was that this is in Colorado, in a suburb of Denver. I don't remember the particular suburb, but the mayor and a city councilor had gotten in a public dispute about policy, which is quite common, where you'll have and I misspoke, it's the police chief and the city councilor, not the mayor. The police chief and a city councilor had a disagreement about public policy direction, and the city councilor chose to criticize the police chief. And this woman who worked for protective services in Colorado, for Child Protective Services, she says, well, I'll just cook his little goose. And she submitted a false report about the police chief, and it did not go well for her, and she was sentenced to incarceration for that false police report. 4 years is an awful long time. I would have to know what if any of her criminal history was like, and what type of diversion options might have been appropriate. But I'm not for extremely harsh sentencing. But on the other hand, we need to send out some deterrence of making or causing false police reports to be made and causing someone to be subject to this type of. It's awful to be arrested. Can you imagine the guy in Pennsylvania? What did everybody think about him when he was in jail? He was in danger of being killed. He probably lost his job. He lost all of his friends because they thought he was a rapist. They showed his picture of his truck and everything on TV, and turned out that it was all made up. How does he get justice? How does he get redemption? How does he fix his life? He's got an arrest history. What is the opportunity for expungement in Pennsylvania? And even if he gets an expungement, the FBI never expunges anything. So it's always lurking beneath the surface there for criminal justice agencies to say, oh, if he were to have a minor arrest, say moves around the country to Idaho and he gets arrested for something, the first thing the pretrial services is going to do when they run the background, oh, well, you're arrested in Pennsylvania in 2024 for rape and attempted kidnapping or whatever. Well, those were dismissed. Oh, but you were arrested for it. I mean, that affects bail decisions, does it not, Chance?
Oh, it does. And that's why it's so important that if there is a factual innocence aspect of any statute within that state, that you take advantage of that, because otherwise it's going to be exactly as you say.
So I've sat in what we call felony first appearances. I've sat through those many times in our professional career here. I've sat through those. And when they call a case to set conditions of release for a person who's been arrested, the pretrial services have done a background report, and all that is read by the prosecutor for the judge. And the judge looks and listens to those previous arrests, any no-shows in court, any failures to appear, and determining what kind of conditions can be fashioned. And if this man has this sexual arrest on his record and it cannot be removed, it's going to be potentially a problem for him down the road. And there needs to be some kind of way that this woman is held accountable for that. It's not funny at all.
Not funny. You said, oh, I think it's funny. It's not funny.
Well, her being in jail is funny.
Not for her either. She could die there as well. And I don't think that what she did is deserving of the death penalty.
Well, he could have died a lot easier than she could have for the type of allegations she put on him. He was much more in danger than she is.
I won't disagree with you, but that doesn't mean that there's not a riot that goes out and all of a sudden that you end up with a shank in your gut.
So, yeah. Not funny. All right. Not funny.
Yeah.
California Corner. Take it away, Mr. Chance, in that corner over there. Ding, ding, ding.
Okay,
Go for it.
in the California corner. Well, we're talking about putting the jack back in the box. And, as I listened to the questions and thought about this, it's really relevant in terms of everyone. And really, for California, it's really important. So putting the jack back in the box is really talking about how you get your life back together after conviction. And I'm going to put it in the context of, say, a conviction for a crime involving a sex allegation. So everybody knows this in California, and I'm not sure about the rest of the world, but there is no Department of Rehabilitation in California. And by the way, gentlemen, if you want to jump in and ask a question anytime, I'm always open for one. Okay, so again.
Okay, well, I got a question for you right now. You said it's no Department of Rehabilitation. I thought it was the California Department of Corrections and Rehabilitation.
Heck no. That doesn't mean anything. As theories of punishment change now and then. We have never been a state with rehabilitation as our main purpose. It's punishment. And if I haven't said it again, it's punishment. And I'll say it a third time. It's punishment. There is no Department of Rehabilitation, and the Department of Corrections is a misnomer. So that should clean up that little thing. Now, to achieve rehabilitation for a criminal conviction in California, you must rehabilitate yourself. And a lot of folks will ask, and it's important that they do, when does the process start? Because that is a very smart question. It has universal application, but let's start at the pre-plea. What is the pre-plea? This is what happens before you plead guilty or no contest. Okay, because this is the time when you can show the court and whomever else is interested, and hopefully the prosecutor is, if they're willing to do justice in a case, you can show them that there's a recognition of the issue. Now, how do you go about doing that, even if you don't know what the issue is? Well, one is psychological services. Let's take, for instance, getting a forensic evaluation and risk assessment. A forensic psychological evaluation plays a crucial role in the criminal justice system by addressing important questions and providing valuable insights for legal proceedings. In the context of sex crimes, they can be used to assess criminal responsibility and evaluate risk for future dangerous behavior. This information may be crucial to the appropriate settlement or disposition of your case. And I say that, and I emphasize it, crucial. Okay, also sex therapy. Say you're pending disposition of your case and you want to do something proactive that is gonna help you down the line, including the possibility of a better disposition. Sex therapy, going to a therapist and talking about what the issue or behavior is. The main objective is to help the individual subject of the therapy to avoid risky, aggressive, or reoffending behavior and high-risk situations. And that sounds like a really good idea if you're pending a case, outcome. So it's a good idea. Now, other things can be used as well to benefit you, like Sex Addicts Anonymous, just like if it were Alcohol Anonymous, a fellowship of individuals who share their experience, strength, and hope with each other, that they may solve their common problems and help others to recover. That's a good place to be pre-plea. Now, post-plea. Let's talk about post-plea. Post-plea has to do a lot with probation. Now, there's only really two things to know, and I don't need to emphasize them because I think everybody knows and understands them. Comply with all the terms and conditions of your probation. That's easy. Maybe not easy to do, but easy to understand. And show good conduct while on probation, which means don't violate, don't pick up a new case, don't do things like that. Okay, now, if you finish with probation and you were able to do these pre-plea things, and on probation you were able to comply with all the terms and conditions of your probation, then we're talking about what you do when probation either terminates or expires. Well, this is the most important thing I'm going to say tonight. continue to work on the underlying issues that cause the behavior. It's really, really important. And it is important because it will achieve your objectives down the line in order to reintegrate and to normalize and stabilize your life in the future. For example, additional sex therapy or continuing fellowship in Sex Addicts Anonymous is really, really important. But other things are important as well, things that we all know, like employment, because work provides an opportunity to build friendships and connect with colleagues. Additionally, executing tasks you're good at can stabilize your mood, especially if you're prone to depression. And a lot of folks who have been convicted and have to register are prone to depression. Education. The most important aspect of education is personal growth, which contributes to your discernment and maturity, which helps you avoid what you got caught up with to begin with. Social groups. And I think this is really important as well. It's well established that people who feel socially isolated or as though they don't belong have worse mental health than those who feel socially connected. So getting involved with groups, social groups, like including close friends, religious congregations, health and wellness groups, volunteer networks, and human rights organizations is all very, very, very helpful for your mental health. And it all helps you move along that rehabilitative trajectory. So,
Chance, I just want to chime in.
Sure.
Like all of those, I don't want to say all of those things are restricted to our people, but many of those things are restricted or challenging for many of our people.
Correct.
And that just makes it incredibly hard. Yes, those are all great things that probably every therapist, treatment provider, any of those professions would recommend that you do. Oh, I'm sorry, you can't go, like the app Meetup that just has the volleyball pickup group or cycling group or the chess club or whatever movie group. Oh, I'm sorry, you can't be on that app. Well, what do you want me to do?
Well,
Sorry, you should have thought about that before you committed your crime.
Yeah, that's legitimate. That's legitimate comment. But if you think about it, these social groups are not just that I've mentioned, are not all inclusive. As a matter of fact, there's a million things you can do. Okay, and there's a million places you can go, and you don't need apps. So,
Agreed.
What I'm saying to you, and what I'm saying to everyone is, social groups are important, and find one you can belong to. And if that social group is like a therapeutic group, like Sex Addicts Anonymous, then stick with them. And if that group, is another group, like a church group, or another group, like a human rights organization, or a resource group, like this one, join it. But all of it has meaning, and all of it's important.
So I would like to expand on what Andy was making. The point is that a lot of people are forbidden. Probation invokes this so-called felon association clause. And they say that you can't do these things in these groups because they're felons. Like they won't let them attend the NARSOL conference. They're felons there. They won't let them attend things because they're felons there. And it's like, really? I will guarantee you there's hardly a church that you could go to that has more than 100 members that doesn't have a felon in the congregation. So if you take that to its literal extreme interpretation, you would never be able to associate with anyone, because any group you associate, they're going to be felons. And I think that's something, another conversation one of these days, about this overinterpretation of the felon association clause by supervising authorities. But go ahead.
Yeah,
I would like to do that, though, Larry.
I think that's legitimate too, Larry, except for one thing. With probation, I don't go into that, and I'll tell you why. Because I'm so busy complying with all the terms and conditions and showing good conduct, I might not have time to do exactly that. This part of what I'm talking about is post-probation, which means you've already finished with it. So once you've finished with it, that's the time to really connect.
Right.
And because I understand exactly what you're talking about, and it's the most difficult thing to do. But if you asked me, when does the process start? At pre-plea, at probation, at post-probation. I'd say, if I want to get that answer right, all of the above. And then once I've engaged in those things, and it doesn't have to be every single one, but a good many of them will help, I'll show you how they work. How do I document my process? Before I do show you how they work, memorializing your efforts and progress is essential to meeting your legal objectives at a later stage of rehabilitation. Otherwise, what do you show for it? Like you'd be the invisible man. Organize the following areas of documentation and keep them in a safe place where they can be easily located, like psychological evaluations, risk assessments, progress reports about sex therapy and probation, self-help, additional therapy, fellowships, all that stuff. Keep a file. Keep it safe. Keep it so you know where to find it. So this is how you use it. How do I make my rehabilitative efforts and progress work for me? Now, this is where you're going with this. And you're going with this in California is right here at legal objectives. Termination of probation. Judges will consider granting your petition for early release from probation if you have met the following eligibility requirements: fully paid all your court fines and restitution, completed community service, don't have any new arrests or pending cases, not on probation for another case, and complete at least half of your probation period. Successfully completed all obligations such as court-ordered classes and counseling. So look, if you meet these eligibility requirements, and they should sound familiar since we've touched on almost every single one as we've gone through this, the court should grant early termination of probation if your good conduct and reform justifies the action. And typically, this means that the court believes that you're not a risk to public safety. Sound familiar? And you're not moving your life, and you are moving your life in a positive direction, which means the rehabilitative trajectory. Second of all, once you achieve that, let's just say you achieve termination of probation. Dismissal. If a defendant has completed probation or has been discharged early, as mentioned above, they can petition to withdraw their guilty plea or no contest plea and enter a plea of not guilty under Penal Code Section 1203.4. That is just an incredible, wonderful thing that California offers. On top of which, if you're successful at doing that, you can move on to reductions. Because if you successfully either got your probation terminated early or get a dismissal which says you completed it without violation, that goes far in helping you achieve a reduction. And a defendant can request a reduction of a felony conviction under certain circumstances, as we've discussed in prior episodes. This typically occurs after either early termination of probation or dismissal. The court has the discretion to determine whether to reduce your felony conviction to a misdemeanor under Penal Code Section 17B. The court will consider several factors in determining whether to reduce your conviction from a felony to a misdemeanor, including the nature and seriousness of your offense, but more importantly, your behavior while on probation or under court supervision, your prior criminal record, and more importantly, any other mitigating or aggravating factors in your case. And all the things I mentioned before go into mitigation. So it's almost built for you to achieve reduction. And then, furthermore, if you're on the list, and that's the context of what we're talking about right here, sex registrants can petition for removal from sex offender registry from the California Sex Offender Registry based on the tier of their offense. To be suitable for removal, individuals must not pose a threat to public safety. All that work that went on before, all that stuff goes into that very standard. And if you achieve that, that's wonderful. But regardless of that outcome, there's always a certificate of rehabilitation, which we've talked about in prior episodes, including the last one, which is a court order that indicates that someone who is convicted of a felony or a listed misdemeanor sex crime and served time in state or local prison has been rehabilitated. It doesn't erase your criminal record, but can offer benefits such as improving employment or housing opportunities or help when applying for professional licensure from the state. All these things have a common thread, and they all tie in with each other. They're all rehabilitative, and they all all build foundationally on the other. And that, if I were the Department of Rehabilitation, would be a form that I would put down and have everybody look at and understand before they went out and start it from day one. So, gentlemen, what do you say about that? What do you say about rehabilitation, the great state of California?
Go ahead, Larry.
Well, I say that I'm continue to be intrigued about that certificate of rehabilitation. I would like to have that in our state. And I'm also intrigued by reducing your crime after the fact, showing your rehabilitation that you can have a crime adjusted downward. Is that what you were talking about, a wobbler, or is that a different thing? Because we talked about a wobbler last episode.
Right, that's a felony. That's a crime that can be charged either as a misdemeanor or a felony, which is called a wobbler. And if it is a felony, yes, it could be wobbled down to a misdemeanor, which is incredibly wonderful.
But in terms of the reducing the severity of an offense after rehabilitation, I'm guessing there are offenses that are excluded altogether that just aren't eligible. Would that be correct? That you can't reduce?
Yes, that would be correct. But one interesting thing about this, in terms of reductions, people think that there's a time limit. Hey, I can only do it, during a specific time. Well, there was a case called Meyer. It's a 1966 case, and I often have brought it to court when a prosecutor says, hey, wait, it's late in the game. That was 10 years ago. No, it can happen at any time after probation expires. And that is such a cool thing. And, that's just, it's not limited by time or space. I just love that.
Well,
PA Dad says, Chance is making California sound like a great place to commit a PFR type crime. It sounds like there's actual rehabilitation, which you don't hear about in most states.
Well, I'm not so sure you'd want to commit anything here, but I will say this. This state, even though it's been overshadowed by a lot of stuff, is still a very progressive state in terms of rehabilitation. And I think that, when you look at this, when you look at it from, the overhead view, it's very impressive.
Well, you certainly are way ahead of us in terms of what we're doing. And I would really like for us to have that certificate of rehabilitation. And I'd like to figure out a way to incorporate it for people who have non-New Mexico convictions as well. Because if you've lived decades and decades of exemplary life, and you're from Mississippi is never going to pardon or expunge or do anything for you. So you shouldn't be saddled with your Mississippi baggage for the rest of your life.
Mississippi would be one of those states where they would do Judge Dredd type things and, oh, hey, you jaywalked. Sorry, death.
Not cool.
Not quite that bad, but I would like to figure out how to expand the opportunity. Now, I know the argument's going to be that we'll become a haven for people running from their past. That's the pushback that we'll get. But there's got to be some balance that you can do to make sure that we don't become a mecca for that, but to also give people that have legitimately moved here. Maybe what we would do is that they had to have lived in the state for a certain number of years. That way you don't have the people coming just for the opportunity to try to apply for that. If you've been a New Mexico resident for 10 years or something, then you can apply for a certificate of rehabilitation.
That'd be nice.
So,
well,
are we recording an episode next week?
Probably. I would think that we would record next week, and then there's the conference after that, and then who knows after that. Okay. I got nothing I can say about the 29th and then forward.
Okay, so we are on next week. All right, sounds good.
I believe so. Well, very well. Larry, what are these two good news things, and then we will wrap it up?
Well, the two good news things are about voting, I think. And
yes.
The Nebraska has restored felon rights. They've removed the 2-year waiting period. So you get off supervision to complete your obligations. And then it looks like that Pennsylvania has made it where people incarcerated can vote. And I didn't dig deep enough into that. But if somebody from Pennsylvania wants to dig into that, we can get further into it. But it looks like they're going to join those liberal lefty states like Vermont and up in the Northeast, and I think Maine, where they let people who are incarcerated vote. And
because that's not what the title says. It says who have been incarcerated. That's not who are incarcerated.
oh, well, thank you.
I mean, that's the way the title reads. These are just people that have been out. Maybe they're still on supervision of some kind, whatever. They can vote.
Okay, well, let's see. It's the Philadelphia
Still
Inquiry.
good news.
But yes, it's good news that everybody says I can't vote, and they pretend like they can't influence public policy. You can vote. In many instances, you can vote, and you just don't realize it.
Yep. And that's where people go around to typically minority type neighborhoods and get out information drives to let people know that they very well might be able to vote.
So, yeah, that was behind a paywall. That was the reason why I didn't do any workup on it. I couldn't actually read it.
One of these days, Larry, we will teach you how to get by the paywalls.
Well, I don't like to pay.
Again, never mind. Never mind. Simple little plug into the browser. You can get by the paywalls. But anywho, we had new patrons. So thank you, Caden and Matt, who just joined just before the show. And he's the one that we were talking about, the Missouri, Kansas person. Thank you both very much for joining. Caden did a whole year long, and Matt just did a monthly, go by, pay as you go kind of thing, but that's all good. Head over to registrymatters.co for the show notes. You can leave voicemail at 747-227-4477. Email us at registrymatterscast@gmail.com. And of course, as I just mentioned, support us on Patreon at Patreon, Patreon, patreon.com/registrymatters. Chance, I hope you survive the heat. And Larry, I hope you survive the nice weather.
Thank you.
All right,
I may have had that backwards on purpose.
And I'll see you next week, maybe.
Very good. Take care. Have a great night, gentlemen.
You too.
You've been listening to FYP.